understand there's times for mercy, there's times for compassion, Your Honor, but I think undeserved mercy to the guilty is cruelty to the victims, and they've been through everyone's worst nightmare. 20 plus 20 is 40, and that's really not enough, but that is the maximum allowed under law, and that's what I'm asking you to do on behalf of the Marty family, the Eisenhower family, Christopher Staggs, Boston Carr, and their entire faith community. The one reason all these people, including the Gomez family, are here in this courtroom today is because of what he did, what he chose to do. And it is a tragedy up and down. And so I'm asking you to protect the citizens of Jefferson County from any chance that this could ever happen again from Mr. Gomez. Thank you, Your Honor.
Thank you. I have a question, Mr. Nichols, with regard to deadly weapon finding. I'm looking at the indictment, and it doesn't read that there's a deadly weapon.
Right, I don't believe it does, Your Honor.
Okay. And it's not something I looked into. Is that something I can still find if the indictment doesn't say it?
Yeah, I don't have an answer for that.
Okay. Do y'all know? If it's not, if it's not in the indictment?
The court would have to find, it is permissible without a request, without it being included in the indictment. However, the court would have to point to specific evidence that it was used or intended to be used as a deadly weapon.
Okay.
And I would argue to the court that perhaps, I mean, if there had been other evidence, but there's really no evidence admitted upon which the court could make such a finding, so I would ask the court not to find that. But I will represent to the court as an officer of the court that it is not absolutely required that it be included.
Okay. I really didn't think so. I just wanted to make sure. I would think I guess, Mr. Young, would you disagree with the information that is provided in the pre-sentence report that everyone has agreed that I review, that I could use that as far as, since I've taken judicial notice of that, the letters and everything else, that would be, would you have an objection for me, of me using that if I were in fact to make a finding of a deadly weapon?
Your Honor, I think the court can consider all evidence before the court, and if there is evidence that the court can point to that says this supports the finding of deadly weapon, obviously we can't contest that.
Okay. First, I really do want to thank everybody for being here. We don't have full courtrooms like this. These, just as both of the attorneys said, these are some of the most difficult cases that any judge has to deal with for many reasons, obviously. Mr. Gomez, had you been in, well, I'm not sure that it would matter, but had you been in here and this was your first DWI, there might be some sense of what your attorney was asking for me, which is true. I mean, I have to detach myself from the emotional part, which is, it's impossible, but it's required, and I do the best I can to do that. And there are things about you and your life in the past that are good. There are things that the 3 prior DWIs should have taught you. Your age, you're 52 now? 53 now. You know, it's the 3 DWIs previously, even though they're older, and your age, it's not the establishment's fault. Did they violate the law? Absolutely. You're a grown man. Grown man. Got into a vehicle, and you know from your history, you know from your age, you know probably from telling your own children not to drink and drive, and trying to probably instill that in them, and you did it, and you did this. So at this time, in cause number 24 DCCR 1651. I'm going to find you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. I'm going to sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. I am basing that on all of the information that's presented in both the pre-sentence report, the attached reports from the officers, in addition to the letters from Mr. Stacks, who unfortunately had to drive up and see this in person, from what they had to use to identify these two precious young lives, that there's no way that there is any doubt that you used your vehicle in a manner capable of causing death, and that you in fact did that. In cause number 24 DCCR 1652, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter with a vehicle. Sentence you to a term of 20 years. There will also be a deadly finding in that case based on the same information and evidence that I used in the previous one. That sentence will run consecutively to cause number 24 DCCR 1651. In cause number 24 DCCR 1653, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient. Which one are we, what cause number?
Oh, just we're going to go on 523,
Okay.
352, and 431.
Okay.
With the dismissal of the remaining case.
Tell me which one we're dismissing. That'll be the easier one.
Okay, we're dismissing 353.
353. Got it. Thank you. Good morning, sir. Are you John Jones?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading in each case of the indictment?
Yes, Your Honor.
And obviously, Mr. Coleman, you've taken everything into consideration with regard to the facts, the jail incidents, as well as the wishes of the family in making these offers.
That is correct, Judge. And just for the court's information, there is a member or members of the victim's family here in the present room today.
Okay.
And I've conferred with her about the case.
Okay. Mr. Jones, this is difficult for me because based on your behavior, honestly, I don't want to go along with anything. But it sounds like if Mr. Coleman has discussed this with everyone and understands the underlying facts of the offenses, what has been going on in a jail, I'm going to go along really only because I trust him to the extent that I do. Do you understand?
Yes, ma'am.
In cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
So you're charged in 24 DCCR 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? And then finally, in cause number 25 DCCR 1352, you're charged with the first degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with? I have here on the tablet in all three of those cases documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
No.
State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These 3 cases will run concurrently, which means together at the same time. I'm going to hand you in all 3 of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Wilkerson. Now, let me tell you one more thing, Mr. Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready to get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave. Prove me wrong, and that would be great. If you figure it out and start learning how to mature and act like a normal human being like the rest of us. But my money is on you not doing that. So I wish you'd prove me wrong, because everybody that has to deal with you, they're just doing their job and you're putting them through all that. Is there a victim impact statement?
No, Judge.
Go back with the bailiff.
He pulls a gun on a 14-year-old kid and steals not only that kid's dirt bike, but also a small amount of cash from that 14-year-old. The PSI indicates that 14-year-old is so traumatized by this that he can't even attend public school anymore, Judge. When he was apprehended with that stolen dirt bike, there was a vehicle associated with this defendant. And in that vehicle were other subjects who had 4 firearms in that vehicle, Judge. And as if that was not bad enough, he goes on to brag about this criminal activity on social media. And if that wasn't bad enough, Judge, he goes on to taunt the victim of the UUMD on social media as well. Judge, he is youthful. I'll acknowledge that. He does not have any adult criminal history, Your Honor. I will acknowledge that. But, Your Honor, what he has engaged in is beyond the pale. He needs prison time, in my opinion, Your Honor. And that's what we're asking this court to do. If somehow, in any way, shape, or form, the court's considering community supervision, we'd ask for shock probation, some prison time up front, and then shock him out on community supervision. Judge, again, this is just beyond the pale. And I think the PSI speaks for itself. Thanks, Judge.
Mr. Chopin, cases for me with kids your age are so hard. And I have for a very long time tried very hard to give chances. But all of the guns and the riding around and so you're January 2019, you're put on January of 2019, you are put on probation, juvenile probation. You violated it 1, 2, 3, 4, 5, 6. On your 7th time to violate, they finally sent you to TJJD, right? 7 times you were given an opportunity. You go to TJJD, obviously you're not there very long because you get out, and then in December of 2022, you commit an unlawful carrying a weapon, evading arrest or detention, and you're again put on probation. You're given another opportunity in January of 2023. So in this year, you were put on probation for a gun case and an evading case. While you're on that probation, after you've been to TJJD, you commit these 3 offenses while you're on probation. So none of it makes sense that I want to do better. And I mean, all this riding around with guns and masks and stealing, and it's just crazy. It's just crazy. Go to see in the jury box. I gotta think about this one some more for a minute. So what I've done, in addition to obviously just thinking about it and looking at all of this a little bit more, is ask and get any incident reports that you've had since you've been in custody. And Mr. Chopin, I appreciate Mr. Lewis and what he's done and the arguments he's made for you. And like I said before, it really kills me to what I feel like I have to do to you young people. But we are in Jefferson County tired of young people running around here with guns. You put a gun to somebody's head. We're lucky you haven't killed somebody, because that's the path you're on. You've had opportunities at probation, and unfortunately, those haven't worked. You've actually already had 2. You were sent to TJJD, you got out, you still committed offenses, and then you got probation again, and then you're here. So all this talk of I want to do right and I'm going to do better is just a bunch of baloney. The way you can't follow the rules in jail shows me same pattern. You can't follow the rules. So at this time, in cause number 23 DCCR 0993, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. I'm going to sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to receive. In cause number, and these were all just open. So in cause number 23, DCCR 0991, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 0992, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 25 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative weapon, finding of a deadly weapon. These cases will run concurrently, which means together at the same time. So I am denying the state's motion to accumulate, which is a gift to you. I am going to grant the state's motion to forfeit the weapon, which is a Taurus Millennium G2 pistol bearing serial number TIP 10158. I'm going to hand you, I need there should be an admonishment showing that I signed it. It wasn't a plea agreement, but I don't see one printed out. Mr. Chopin, I take no pleasure in giving out a sentence like this, but I feel like what I have to do is protect Jefferson County from people like you, who have continued to show that you're just a danger and becoming more and more of a danger instead of learning from the opportunities that you've been given. You will be handed in just a minute a trial court certification in each of your cases that shows these weren't agreements, so you do have rights to appeal, and you can talk to Mr. Lewis about that. I hope you take advantage of any programs. You're still young. You're going to get out of prison and you're going to be young still and have a lot of your life ahead of you. I hope what you do while you're in prison is do what you're saying you really want to do, is get your life together. There's programs you can get out. You can have education when you get out. They offer that, and hopefully be a productive member of society instead of going down the wrong path that you've been going. All right, good luck to you. You can go back with the bailiff. We'll get those forms printed.
Yeah, I appreciate it. I'm just on that defense strategy where it's great when you get to
Good morning. Are you Caden
Yes.
Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense, not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one.
No objection.
Make that states two, because this one was the plea admonishment documentation, please.
I'm offering states two.
No objection.
States two is admitted.
Permission to publish, Judge.
Yes, sir. Any other evidence or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just like,
Mr. Rojas, you may make argument first.
thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over again, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer, because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick. and you'll have another chance to send him to prison probably for a longer time.
All right, thank you.
Yeah.
What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're going to pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation, let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison, you're still going to be young, and you can make your life better. Let's see. All right, so you're Bryce Thomas, and Mr. Thomas was previously in court, entered pleas of guilty in cause number 24 DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24 DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24 DCCR 0391, pled guilty to the state jail felony offense of theft of a firearm. Cause number 24 DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State action.
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
reviewed them one evening.
State reviewed all 35 pages.
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, sir.
All right, Mr. Burbank, you may proceed.
Your Honor, this is a very young kid that in a very short period of time jumped or stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was engaged by his family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons are off the street and back into the department.
Could you speak up a little bit, please?
Oh, back into the department. We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that you can do. At the very end, state jail does, I believe, the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, that you do place him on probation, so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if you can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
Well, you don't have to say it. I could just say it's just young, dumb, just being in jail at a young age and not really knowing that. I got write-ups.
Yeah, but once you get several write-ups, the whole point of growing up is to learn from your mistakes.
Yes, ma'am.
So if you keep getting write-ups, then you can't just say I'm young and dumb. So I keep getting write-ups. I don't disagree that you're young and dumb,
Yes, ma'am.
but this is ridiculous. I know our jail cannot wait for you to get out. cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, I made the state's position clear and I sent some memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in the state's report,
Yeah.
which I believe are.
Still in out of cop cars.
It's still in patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which the photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement. Your Honor, long gone are the days where there's a low caliber Saturday night special that these kids use, in some type of a crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I'd ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for on some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think
because when would it start?
it will start after he finishes his period of incarceration.
Okay. So whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
I don't believe so either, Judge. But again, I'm happy to get you some case.
No, I appreciate the idea. Again, we've done it sometimes. What are y'all doing? What are you doing with all these?
In Texas, a judge
Not shooting people.
Sir?
Not shooting people.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns?
No.
That's all that's happening with these guns on the street is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do you?
I have before, but
Have you?
just
Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm going to do, because I agree with, but Mr. Coleman, I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not going to go make that type of bad decision again. But I'm not giving you probation on everything. You want to change your life and do better and not be young and dumb, you're going to have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody. And part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the Institutional Division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that?
Mm-hmm.
With the deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
I
The fourth,
understand that, but a sexual, kind of,
May I respond, Judge? That is a reduced, to a reduced charge.
I agree.
I point that out.
Can I give a straight on indecency though? Hold on. I think it has to be deferred. Hold on. Yeah, it has to be deferred. Okay, so I'm going to go back in that cause number, which ends in 0392. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then if you violate that probation, you could be sentenced up to 10 years in that case. So you're going to be under supervision or in custody for a very long time. So if you really want to change your ways, you're going to have every opportunity to do that. If you don't, you're going to end up, number one, you're probably not going to make parole if you keep acting like you've been acting here. If you get to prison and you act like this, you're not going to make your parole. You're going to do that whole 7 years. That's going to be up to you. The sooner you get out and act right, the sooner you can start this other probation and get off of it, grow up, and maybe change your life. That's going to be up to you. On that deferred, I am going to order a $500 fine that you follow all of the conditions of probation. That's going to include sex offender treatment, going to whatever classes are necessary, staying clean, not getting in any trouble, all of those kinds of things. Do you understand? Mr. Coleman?
Your Honor, is there a deadly weapon finding option with these weapons?
I don't think so.
Okay. Okay.
Unless you can, I don't think that's,
We didn't allege it.
well, and they're not, possession of a prohibited in the 3G. So I don't think we can.
Okay.
Yeah.
Sorry.
All right, so all of these are actually wrong because y'all marked off plea bargain and there wasn't a plea bargain. So I'm going to hand you the trial court certification in all of your cases. This shows that these were not a plea agreement.
it was a plea agreement, Judge, because it's a, no.
Oh, because of-
No, there was an unauthorized use that we agreed would be dismissed.
And also the lesser offense in that. So there was consideration taken. So this was an agreement, at least for those reductions. Okay. So you have waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. You can go back with the bailiff.
I thought you,
Yeah.
we have Mr. Jenkins that you're going to.
Mr. Williams?
The charges are all the same in each case, Judge.
Yeah, I gotta go through them. Okay. In cause number 22-40823, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And in cause number 22-41018, I also have a first amended motion to revoke your community supervision. Again, also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. And again, that was a 2-year sentence that was probated for 5 years, correct? And then cause number 22-41019, also have a first amended motion to revoke your community supervision. Also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that also correct? Speak up, please. Thank you. All 3 of these motions allege that you violated your probation. Count 1 alleges in each case that you failed to report as directed to the probation department December of 2024 and January of 2025. And is that true or not true?
True or not true?
Count 2 in each case alleges that you failed to provide verification of completing the theft program or the theft prevention class. Is that true or not true? Count 3 in each case alleges that you did not provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
MRT program. MRT. True. That's what we're talking about.
Count 4 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 in each of these cases freely and voluntarily? And did you plead true because all of those counts are actually true? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each case?
Objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in each of your cases, I'm going to find that you enter your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 22-40823, revoke that probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-41018. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-41019, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. When you entered your pleas in these cases, I went over with you the fact that you're ineligible under Texas law to possess a firearm or ammunition. I'm attaching a copy of that because of the judgments. You are ineligible to possess a firearm or ammunition, and if you have questions about that, you can read that document or talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Morning, sir. Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
I did. Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on, let me, get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and do 2 things. The first is to determine if you're guilty or not. And then the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with a cap of 15 years in prison. No. You can go back with the bailiff. Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial and you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff. All right, are you Robert Lowe? Yes, ma'am. And so Mr. Lowe was previously in court, entered pleas of guilty to 3 cases of possession of child pornography. There was an agreement in those 3 cases for a 7-year deferred probation and a $1,000 fine with dismissals, I think, in 3 or 4 other cases. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your
I feel like this is different from some of these types of cases because Mr. Lowe was actually involved in creating with his own family member victim who was very young, 5 years old. So this wasn't I downloaded something and didn't realize what I was downloading. This is very different. This is a family member that was victimized because of this. Don't talk right now, okay? And so for those reasons, I do not feel comfortable accepting deferred probations in these cases. So I'm going to reject those plea offers. I don't know, honestly, I haven't thought more about what I would be amenable to other than potentially just letting a jury decide. I'll reset it one time, you guys negotiate, see where you are on it, and if you come up with something, you can contact me. Otherwise, we'll get rejections and get his cases set for trial and let a jury decide one way or the other, okay? I'm just not comfortable with this at all. You can go back with the bailiff.
But I already signed for probation.
I don't have to accept your probation.
I wasn't told that.
Yeah, you actually were, because we reset your case for sentencing. And here's the thing, it doesn't matter if you were or not. I'm not accepting the plea agreements, okay? There's nothing you can do at this point other than Ms. Holmes will be out there to visit with you about any other options. And if you don't like those options, or if I don't like those options, then ultimately, that's what a jury is for. If everyone can't agree, and then we get a jury to come in and determine if you're guilty and what the punishment is, if you are found guilty, okay? So let's see where we're, I'm not gonna consider any bonds at this time.
Yes, Your Honor. I just, his mother is here, and so, but just for the record, because I have spoken with her on several occasions, as well as with Mr. Lowe, they did keep asking me if he would get out today, and my response to both of them was that it's up to the judge at the end of the day. So
Thank you,
I
Ms.
told you
Holmes.
that yesterday.
Yes, ma'am.
When I visited with you.
Yes, ma'am.
And I told that to your mother.
Yes, ma'am.
That ultimately it's up to the court on whether you would be released today and placed on probation.
Yes, ma'am.
Thank you, Ms. Holmes. You can go back with the bailiff.
I can't say nothing else.
It's probably not wise right now, okay? Go back with the bailiff. All right, so Mr. Spites tested positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled.
Community supervision in the community where they are charged with crime. I think it's important that his actions did not occur in Jefferson County in this case. He has a delicate situation right now, Judge. He has 5 children who are very, very small. I think 3 of them are babies or so infants. Additionally, as this PSR shows, he has pending cases in Fort Bend right now. He's going to court on those cases. He's dealing with those. I think having him in ISF is going to create much more of a stressful situation for him in providing for his children and dealing with those cases and resolving everything he has going on than it would to help him. And I think the point of community supervision is to help the people who enter into it. He's willing to do all the other conditions of community supervision, drug testing and all that. I think that if ISF was recommended partially because of him admitting to marijuana use. He's willing to.
If I test you this morning, you gonna have it in your system? All right, so Mr. Spites tested positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case or cases.
If I may,
Yeah.
part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional
type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay. And I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important, that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through, probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime is actually committed in. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with some inpatient ISF up front. So it's not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life and be there for your children, then you got to figure out how to stay clean and make some better decisions. So that's what's going to happen today. Any reason not to go forward with sentencing at this point?
No, Your Honor. No, Your Honor.
Just my only concern with that is the other pending cases and
Probation when he tests positive with this kind of history, and with technically 4 felony cases pending in 3 different counties. So,
I have to ask Judge, my next question was going to be, is there typically a report date that could be given for ISF for the attorneys in for it?
No. And so what I'm going to do is I'm going to order it. And then once he's in custody, if you'll let obviously Harris County know that he is in custody. And if they will put a hold on him and come get him, I'll release the ISF hold while he goes and takes care of with that. Same thing with Fort Bend. But then if those are going to be probations or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we've still got him for ISF. Sometimes what happens if that process takes a really lengthy time, then potentially if I feel like it's a good enough time, then I can hold that at abeyance at that point and require something like JCDI, which is outpatient. But based on the positive drug screen today and based on this criminal history and what all's pending, he's not walking out of here today. So we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred, get those cases taken care of.
And I'll reach out to those DA offices, Judge.
Perfect.
Maybe with the court's order, they would be willing to negotiate
something quickly.
Yes.
So, Mr. Spites, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution. And you're ordered to enter and successfully complete. Mr. Spites, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity for you. I know it doesn't feel like it today, but you have a great opportunity in this case, number one, without another felony conviction, and to be able to serve any sentence while you're out on probation. I want you to make sure you understand, though, what the consequences could be if you violate this probation. So if you choose to smoke marijuana again or not show up for an appointments or whatever it is, then you're looking at not just a sentence of the theft of property, which is the 3rd-degree felony. You pled to an enhancement, which means if you violate, you could be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can be successful. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can go back with the bailiff. Ms. Hawkins can visit with you back there, okay? Yes, sir?
Okay.
fact that, okay, already y'all taking me in, that means like I can't get out from here. How can I get out so I can be able to handle court then?
We're going to let them know that you're in custody and they'll come transfer you over there from our custody.
Okay, so that's what I'm saying. That's what I'm trying to understand. Okay, if I'm on bond with them, like how would that work?
Ms. Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you, Ms. Hawkins and Ms. Morfino. All right, ma'am, are you Lauren Bridges? And Ms. Bridges was previously in court, entered a plea of guilty to credit or debit card abuse. I received...
Just for the court's record, she's still in treatment, Judge.
The restitution in the amount of what?
It looks to be between 600 and 800, so I'd say we go on the low end.
Okay,
In all fairness.
yeah. Any issue with that?
No, Judge.
So I want to know more about treatment because it looks like there's a pretty serious issue, and what I had written down here was inpatient treatment, but
She went to treatment, was in treatment
Right.
before the warrant came out. And then once the warrant came out, she turned herself in, and then once she bonded out, she went back to treatment. Well, you can tell her what you're doing now.
Yes.
It was inpatient, it was in-house treatment, right?
at Riverwalk Ranch.
Yes, still there.
So you're inpatient there?
Yes, ma'am.
And how long is that program?
It can be up to 6 months. I do have a recommendation, if it's okay, if I go from there onto sober living, that they're agreed with. On the 10th, I'm supposed to be graduating their program and going into sober living in Tarrant County, which is Fort Worth.
I have several letters from them. This was prior, I don't know if they're really applicable to this, but.
So February 10th is graduation day?
Yes, ma'am.
And do you have any information specifically about the sober living place? Do you know what it'll be? Do you already know information about where the sober living is going to be, or will they tell you when it gets closer?
It's gonna be in Tarrant County, which is in Fort Worth, Texas. I don't know I'm not gonna know the exact address until the 10th. I could possibly get back there today and see if we can get an address today.
Okay, all right.
And I can send it in.
Okay. You'll need to obviously get that for probation, because the first step of once you're on probation is going to be to get your case transferred to Tarrant County.
Yes,
and then whatever the requirements or conditions that I set, you'll be able to do there in Tarrant County.
Yes, located.
Okay, sounds good. All right, so it sounds like you're on the right path, Ms. Bridges. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But I'm going to probate that for 5 years. You're ordered to pay the $500 fine, also ordered to pay $600 in restitution, excuse me, and to follow all of the rules and conditions of probation. That is going to include continuing and graduating from the Riverwalk inpatient program that you're in now. Also following through with whatever their recommendation is for outpatient care, the sober living. I'm going to I'm going to allow you to do all that, but I'm not going to just allow you to do it. I'm going to require it. Okay, so you can't leave there unless they say that you have gone to the next step, or you are an outpatient, you can live on your own and all of that. Part of your order now and part of your probation is going to be to follow all of those recommendations, okay? If you do everything you're supposed to, this is a great opportunity, because for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, if you relapse, if you end up committing a new offense, whatever it is, then you're going to be back here in court and you're going to be facing that 2-year sentence that you just agreed to. I'm handing you the trial court certification that shows this was an an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Ma'am, come on back again.
Oh, you want an example out of it? Let's see.
I'll make an example out of anybody. Hang on. You want to stand here?
You don't
want to stand here and be disrespectful?
No,
I will make an example.
Understand my situation. Like,
I don't care what your
I'm not
situation.
making no excuses.
Okay.
I take accountability.
Good morning, ma'am. Are you Brittany Davis?
Good morning, yes.
And Miss Davis, did you get someone hired?
No, it's kind of expensive, but really expensive. I'm not even working right now. But I went through.
Who'd you talk to?
The legal aid. I put in an application for legal aid.
Okay.
It's a place that help you get a lawyer, but they say it could take 6 months to a year. So.
Okay. So did you talk to any other lawyers like I told you to?
The first 3 that I talked to, wow, I talked to like probably 8 of them. But the lowest there goes like $2,000 to start off.
Do you have the names of the lawyers that I asked you that you talked to?
You asked me that last time. I was on.
Right, and then I reset you to talk to them more or get someone hired. So
I talked to Renshaw. I can't remember their name. Renshaw. There's one that's brothers.
Why wouldn't you write that down and bring it?
I wasn't expecting that I had to.
So it looks like you weren't what?
I wasn't expecting that I had to.
So if you're coming, okay. If I tell you to go talk to some lawyers and bring me the names of the lawyers you've talked to, and you don't think you can remember them, then I would think just common sense would tell you to write them down so that you could tell me that you did what I ordered you to do so that you wouldn't go back to jail. Right?
I did do what you ordered me to do.
Okay. So I ordered you to bring back the names as well, not just talk to them, but bring back who you talked to so that I know who you talked to and that you're doing what I asked you to do. Right? Right.
The cheapest ones that I've given you the last time I was here is the main ones that I was looking into.
Okay. But when you left last time, I gave you specific instructions.
Okay.
Right?
Right.
Okay. So are you wearing your drug patch?
Yes, ma'am.
So it looks like back on second. So you tested positive since you've had that drug patch on for methamphetamine.
What is that?
Yep. What does that mean?
I don't. But with the patch?
Mm-hmm. Looks like you tested positive for methamphetamine, and cocaine. Hold on. Let me print it out so I can read it better. So last time you were in here, you had an issue because you had showed up with your drug patch in your hand, so they couldn't test it. So I tested you in court, and then I made you get the drug patch put on again and told you to keep it on. And then the drug patch that was put on January 25th, which was the day before that court date. So you had one on, you had taken it in, you put it on, tested positive for methamphetamine and cocaine. Have a seat in the jury box. I'm going to have you tested this morning, and then I'll decide what to do. Thanks. Actually, come on, ma'am. Come on back up here. I know what I'm going to do. So, Ms. Davis, obviously it is a violation of your bond conditions to use any illegal substances, right? And so you tested positive for cocaine and methamphetamine on that drug patch, in addition to, in the past, not having it on correctly, and you didn't do what I asked you to do or ordered you to do also here. So I'm going to raise your bond at this time for those violations to $100,000. You will keep your court-appointed attorney while you're in custody. They'll be out to see you, and we'll just see what we do with your case at that point. You can go back with the bailiff.
Wow.
Ma'am, come on back again.
Oh, you want an example out of it? Let's see.
I'll make an example out of anybody. Hang on. You want to stand here?
You don't want.
You want to stand here and be disrespectful?
No,
I will make an example.
Understand my situation. Like,
I don't care what your
I'm not
situation.
making no excuses.
Okay.
I take accountability.
Right. So you tested positive for methamphetamine and cocaine.
I don't know how the patch work, ma'am. I haven't been doing any drugs.
Well, you did something.
I don't know if that's like the patch pick up sweat. I don't know if that's like after the process or what, but I haven't been doing anything.
All right. Go back with the bailiff. Good morning, sir. You're Brandell Griffin. And Mr. Griffin, did you get someone hired?
No, the last time I came, you told me I didn't qualify. I tried 6 lawyers, different lawyers. I couldn't afford them.
Who'd you talk to?
I gave you all the names of those 2.
But since last time, who'd you talk to?
I went back to the same ones, just trying to.
Why would you go back to the same ones if you couldn't afford them before?
I talked to 7 lawyers. Like, they all around the same price, $5,000 more. I can't afford that though. I didn't find anything lower than that.
Yeah. I mean, you filled out the affidavit and by law, you do not qualify. So
I'm trying to ask why is that
because your total income is $6,800 a month and your expenses that you put here are $2,260, which according to this means you have $4,600 left every month.
I told the income was nowhere near 6.
You filled this out. I did it. And you swore under oath that it was true.
What did I sign? I get paid $2,000, about $2,000 a month, and I pay child support. I have 7 kids. I pay child support for.
You put 0 on child support.
I put 0 on child support.
Well, no, you put that you pay child support for it. Yeah, that's all on here.
Yeah, I'm not understanding how it gets to 6,000.
I'm reading what you wrote. Unless I
misunderstood some of the things on there or something. Like I can bring checks to bank accounts, all that. I can do all that. I can't afford it.
Hold on, I'm printing it out.
I was ready to finish this case and like I have evidence the girl to indicate.
I don't need to get it. I can't talk to you about that, but tell me. Do you see the total on the left-hand column?
Because under assets, it has a car. My car is
the other side where you say your income is $6,800.
See that? But I added up assets, which is my car, and I had it worth around $6,000 or something. So I just added that number to that. Like I said, I must have did something wrong. I don't know. But
so you make how much a week?
I make like $18 an hour. I get paid bi-weekly. My check be like $1,200, $1,300.
So bi-weekly about $1,200 or $1,300. So total monthly is about $24. Okay. All right. So then based on that, you do qualify for a court-appointed lawyer. So I'm going to make that notation on here. Step in front of the clerk. She'll let you know who your attorney is going to be and give you some more instruction. Good morning, sir. Are you Jimmy Couch?
Yes, ma'am.
And Mr. Couch, had you, the bondsman, you're on a bond in a misdemeanor case. It looks like on that violation of a protective order.
Yes,
and you were, for the record, you were arrested, it looks like January 29th of this year, 26, on a burglary of a habitation case. Just listen. You were arrested for that, right?
Well, I'm really not sure what I was arrested for.
Okay.
My ex-wife.
Hang on.
Okay.
So you were arrested for burglary of a habitation and interference with emergency request for service, and the magistrate gave you a $25,000 personal bond and just let you were just released from custody.
Yes, ma'am.
After that date, on February 14th of 2026, you were arrested again, and that one for violation of a protective order.
Okay.
You made bond on that case, and you were given a $2,000 bond on that case. All of this information has been brought to my attention, and I am at this time, I've got Mr. Rojas has been appointed to represent you, and Ms. Malfino is here on behalf of the district attorney's office. Based on the fact that you were arrested for a violation of a protective order after you were let out without a bond really on the burglary of a habitation, I'm going to find that you're at large without proper bond on the burglary of a habitation case, which is cause number 26 DCCR 0328. I'm going to set that bond at this time at $50,000. There will be a condition of that bond that you have absolutely no contact or communication with
Allison.
What's the last name?
Couch.
So that means in person. That means obviously communication or in person.
Yes, ma'am.
And if you will also be required as a condition of that bond, if you make it, to wear a GPS monitoring device at all times. Do you understand?
Yes, ma'am.
And then good morning, sir. You're Ronnie Oliphant. And this is 25 DCCR 0379. Mr. Oliphant was previously in court, entered plea of guilty to the third-degree felony offense of injury to a child. I've received that pre-sentence report, and has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
Judge, just based off the statements and some discussions with Mr. Oliphant, we would ask to withdraw his plea. I understand it's up to your discretion.
So, Mr. Oliphant, obviously, I have some notations here. I know exactly what your attorney, Mr. Comerford's talking about. You denied the offense that you committed the offense in this pre-sentence report. But here's the thing. If I allow you to withdraw your plea today, which I don't have to do because you pled guilty after having sworn under oath that you were going to tell the truth the other day when you were here for your plea. If I allow you to withdraw your plea today, there will be no plea bargains whatsoever accepted. If you want to go to a jury and let them decide, then that's your right. If you didn't do it, then it's going to be up to a jury. We're not going to get down the road a few months and a jury's here waiting outside, and all of a sudden you're like, I really did do it. I'll take that probation or whatever it is. If we do this today, I am making a notation. Mr. Coleman, I'm sure, will notate it on his file. Mr. Comerford understands and has been here enough to know that when I say it this way, I mean it. So do you want to withdraw your plea and go to trial?
Yes, ma'am.
All right, then we'll do that, and we'll set it on the next available trial docket. Mr. Comerford will.
Just docket wise, the next 2 weeks, I've got a suppression hearing one day, following week.
Oh, no. The trial docket will be, you're probably about 3 months out for the next trial docket.
3 months, okay.
Make sure if you have it, that kind of gets us close to in the middle of summer and stuff. So if you have any vacation, make sure you get that vacation letter in.
Yes, ma'am.
Look at that. I say we. Ms. Holmes will look at that before that's it. So if there's any vacation, otherwise it'll get set on the next one, which is about 3 months out. Okay. Mr. Whitmire, in cause number 25, DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start? And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed that.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge.
Right.
That was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent?
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? Yes. And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket. Yes. Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you can turn around and try the next one as well.
Yes, Judge. We'll be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent?
It would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right. We'll get it set for trial then. You can go back with the bailiff. Good morning. Are you Joseph Roberts?
Yes, ma'am. Good morning.
Good morning. This is 20-34226. Mr. Roberts, looks like you were on probation for the felony offense of driving while intoxicated, and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment at Level Up Treatment, Texas, that you went to April 26th through May 29th of this year. Mr. Robert, especially you, and raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a scram device, comply with any curfew set by the court. As the court can see, he did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake, and if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we made the court aware with the district attorney. His daughter was brutally murdered about 10 days ago now. Somewhere around there, 2 weeks. About 2 weeks ago. Her daughter's his daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling therapy for alcohol substance abuse. As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have 2 homes, one home that they live in, another home that they haven't been able to sell, so they have 2 mortgages to pay for and bills. Is that correct, Mr.
Yes, sir.
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it, or where is it? What's it through?
It's Trust Health.
Trust?
Trust, TROST.
Trust.
Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on?
That's a group.
Is it on?
I do it virtual. I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
How do you do your random drug screen?
They send an Uber and bring me to Quest on 9th Avenue.
Have you already done one of those?
I have one set up for tomorrow.
Okay.
Yeah.
Where do you work?
There you go.
With Bechtel, Environmental Safety and Health Representative with Bechtel. For LNG.
So how would you get to and from work and things like that if you're not going to drive?
Yeah, my nephew also works out there, same shift, so I can ride with him.
Okay. Just for the record, I am reviewing the court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that it's
not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see, do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor. I can pull it back up.
Ours didn't, because it's an older case, it's not in here. Okay, please, ma'am. I guess an issue that I have that we're going to have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already have been there, done that.
How many set of keys do you own?
Money.
No, to your car.
Oh, I have one, my wife has one.
For the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
I have previous PSI. from-
Sounds like it's coming as well over here. Thank you, Mr. Nichols.
You take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court with the driving. I believe a scram will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay, so Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there will be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond. Do you understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a scram device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever. Period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that, since your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay. So that'll be a condition of bond as well as your probation. Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right, so what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done. Because being in prison won't help the rest of your family. Okay, all right.
Thank you, Judge.
Yes, sir. I'll shoot a message over.
Thank you, I appreciate it.